Hello and welcome, everybody. Today we're going to be talking about inspections on the FAR contract. Going to go through the inspection provisions and talk about some tips and tricks. This is a short form webinar, so it'll just be a few minutes long. Take a minute and take a listen. First of all, the inspection period of the FAR has a default of 15 days, but can be shortened, and often is, to 7 or 10. And during the inspection period, the buyer can conduct inspections at the buyer's expense. If they don't complete the inspections, they don't give proper notice, then the buyer waives their inspection rights and the seller has no obligation to repair. Under the FAR contract, there are basically 3 inspections: the general inspection, the wood destroying organism inspection, and the permit inspection. You can add mold and lead inspections by addendum if you add a rider to the contract that FAR provides. Under the general inspections, you need to make sure that your ceiling, roof, walls, doors, frames, and foundation are generally free of leaks, water damage, and structural damage. Your pool equipment, your major appliances, your electrical, your mechanical all need to be in working condition. And then, of course, your screens, your fogged windows, your missing roof tiles all have to be replaced. Working condition means operating in the manner that the system was designed to operate. So be careful there about versus cosmetic conditions, which are just aesthetic imperfections that do not affect the working condition. Example in the contract is the worn and discolored carpet, wallpaper, window treatment, nail holes, scratches, or scrapes in the walls, ceilings, minor cracks. Those are all cosmetic. Of course, no one knows the difference between a major and a minor crack, but that's for a longer webinar. We talked about this. The structure must be free of leaks, water damage, structural damage, working condition for the major systems. Very important that you understand the difference between cosmetic and defective. Working condition, talk about the pool equipment has to be working, the major appliances, the heating, the cooling, the mechanical, electrical, plumbing, security, sprinklers, septic, seawalls, docks, water lifts, all these little parts of the house have to be in working condition. Wood destroying organisms are an inspection under the contract. You have to use a Florida licensed pest control business. They determine whether there's any past or present infestation or damage. If there's previous damage, then the seller can transfer the warranty and does not have to treat as long as there's a current warranty. If there's a live infestation, then the seller's got to get estimates, and the seller is required to pay for treatment up to the WDO limit. Remember, in the FAR contract, you set your limits, and we'll talk about that a little bit more, but the WDO limit is typically 1.5% of the purchase price. For open permits, the buyer has to notify the seller in writing of any open or expired permits or permitted improvements that they know about, and they have to deliver all of the documents. Then the seller has 10 days after receipt of the permit inspection from the buyer to notice and deliver to the buyer estimated costs. The seller has 5 days before closing for the closing date to close the permits. If they cannot be closed, then you could have up to 10 days for an extension of closing to allow for final inspections. And if the cost to close or the remedy exceeds the permit limit, then the parties have 5 days where the seller can either pay the excess, the buyer can accept the property as is with the conditions as they are. If neither party delivers the proper notice, then either party can terminate. Again, talking about open permits, we can extend the closing, the seller can pay the excess, or the buyer can take as is. This just lays it out a little differently for you. Talking about the cost of the repairs, typically your WDO, your general inspections, and your permit inspections can exceed 1.5% of the purchase price each. So that's up to 4.5% of the purchase price that the seller could be obligated to for inspections under the default. You can change that default in Section 9 of the contract. And if the seller does not complete the repairs during the pendency of the contract, as in after closing, you do an escrow up to 125%, but only up to the cap set in the contract. If you're going to dispute inspection results, the seller within 10 days of receiving the inspection may choose to have their own inspection done. The seller then gives copies to the buyer. If the buyer and seller's estimates differ, then they split the cost of the third inspector, who provides a final and definitive result to both the buyer and seller, and then the remedies and rights go forward from there. So that's a quick primer on Florida's FAR bar contract. Please give me a call anytime, 239-784-5556 with your questions or comments.